Medical negligence. It's on page number 73, chapter 9 of your medical legal textbook. I'll just take a brief session today. So medical negligence, it is an act or omission of any act by the healthcare provider which deviates from the accepted standards of practice in the medical community and which causes injury to the patient. Okay, so it is one of the most distressing scenario. A medical negligence is the most distressing scenario for the practitioners. Okay, so this is the definition given. No need to by heart the definition, just understand the meaning. So you have either omitted or you have purposefully done something which is not the standard of practice in your field. Okay, so that comes under the medical negligence umbrella. Okay, so failure on the part of a doctor to exercise their skill or knowledge or diligence, okay, which are required by the medical professional to do so. And when they fail to do all these requirements and it leads to harm to the patient, okay, it leads to some kind of harm to the patient, it comes under medical negligence. But and a small accident, a mere accident, or if a doctor has an error of judgment, doctor misdiagnosed the situation, something like that, that does not constitute a medical negligence. Okay, a small accident or just an error of judgment does not constitute a medical negligence. Just on the basis of error of judgment, the patient cannot sue the doctor in the court. Okay, so that's the introduction to medical negligence. So there are areas of medical negligence which we'll cover right now. So first is the duty of care towards the patient. So every doctor who enters the medical professional, they have a duty of care towards the patient. Every action, thought, okay, advice given by the doctor to the patient is in the hope that the patient recovers. Okay, the patient is put into the bestest of his or her state. Okay, so that comes under the duty of care. So the complainant, whoever is a complainant, they must show the practitioner, they should show the proof that this doctor owed this duty of care. The doctor was supposed to care for me. The doctor was supposed to take care of my issues, and he or she didn't do so, didn't comply with this particular duty of care. So that comes under medical negligence. Okay, and even if there is no money that is charged by the doctor, if the doctor is giving this service free of cost, still the duty of care towards the patient exists. It doesn't mean that I didn't charge the patient anything, the patient didn't pay me anything, why should I follow my duty of care? It's not like that. Okay, even if you're giving your services free of cost, you have to abide by the duty of care. Okay, so free of cost treatment will not protect the doctor from medical negligent cases. So in which all situation duty of care has to be practiced? The first duty of care is deciding whether a doctor should undertake a case or not. Okay, the doctor, to its best capacity, he or she knows that the case in front of him is it possible for the doctor to handle this case or not? Should this case be referred to some other specialty or not? Okay, so this kind of judgment doctor has to take. If the doctor decides that, okay, this case I can handle, I can start examining the case and start advising treatment for the patient. As soon as the doctor decides that, the case comes under the duty of care of this doctor. Okay, so the first duty of care is to decide whether or not to take charge of this case. That is the first state. Okay, second state is duty of care in deciding what treatment to give. Since there will be options of treatment, surgical, non-surgical, invasive, non-invasive, okay, different forms of treatment in respect to the expenses as well. Okay, so now the duty of care of the patient relies on what kind of treatment should I suggest, what advice should I give, what treatment options should I lay down in front of the patient. That is the second step of duty of care. The third one is duty of care in administration of that treatment, whatever treatment the patient has chosen from the options given. Okay, so when the patient decides, I'll go with the surgery, and when the doctor is also on team, okay, and when both of them decide together simultaneously that, okay, we will go forward with the surgery, administering that treatment during the entire process from start to end of the treatment, duty of care is still under the uh, doctor's part. Okay, the doctor has to take care of each and every aspect that leads to safe health and safe treatment delivery to the patient. Okay, so if there is any breaches in these three situations, if for example, if the doctor knew that this case, for example, a general surgery case is given to an orthopedician, okay, the duty of the duty doctor was an orthopedician and a general surgery case came, definitely the orthopedician will not take up that case because that is not under his expertise. Okay, and still if the orthopedician wants to go forward with the case, that is a breach. Okay, do not handle the case which you are not expert in. That is the first duty of care. The breach in that first duty of care can lead to medical negligence uh, charges. Okay, second, duty of care in not providing the exact options of treatment. Okay, withholding certain information about the treatment, that's a medical negligence. Okay, and then while administering the treatment, while carrying out the treatment, you fail to follow some aseptic techniques. Okay, something like that which put the patient's life into a life or patient's health into harm's way. Okay, that's a breach. Okay, so that's these all situations can construe a medical negligence. Okay, is it clear about duty of care towards patient? Please reply in the chat box. Okay. Second is breach in the duty of care. For example, the doctor whoever are practicing, even though this doctor is not the best among the peers, okay, no, the doctor is not the best practicing surgeon or best of the world known doctors or something like that, still it is considered that the doctor has an average amount of skill that can save the patient, that can treat the patient. It is considered like that. Okay. Okay, so breach in duty of care. So every doctor has been categorized that even though the doctor is not the best in the community of doctors, even though the doctor is not the uh, expert in his chosen field of practice. Okay, even though the doctor is not the well-known one, but it is also always considered, it is assumed that the doctor has an average expertise which is more than enough to treat the patient. Okay, and if at all, even with the average expertise, if there are any breaches on the doctor's part, it can lead to medical negligence. Okay, so that is the breach in duty of care. And even if the doctor does not know how to handle certain latest advances in the technology, whatever new innovations and inventions are taking place, the doctor is not able to handle that, operate those machines. But still, that even if the doctor has basic awareness, okay, these things do exist in the market. These are the technological advancements that are working somewhere in the world. Okay, if the doctor has that kind of awareness, that is more than enough. Okay, that is more than enough to at least advise the patient that, see, I can't perform this, I'm not capable of performing this, but you can go to these places where these treatment options are given to make you feel better. Okay, so that kind of knowledge should exist within the doctor. Next is the damage suffered by the patient. So the complainant, here the patient, should prove in the court. Again, the burden of proof is on the patient. So the complainant has to prove in the court that there was a breach of duty by the patient, by the doctor's side, and because of which the patient has suffered injury. This kind of proof that the complainant has to bring into the court, that because of the breach of duty on the doctor's part, I suffered this injury. Okay, so that kind of proof has to be brought in by the patient, the complainant. Okay, and it should be reasonably foreseeable. Okay, for example, every surgery, let's say, take an example of a cardiac bypass surgery. Okay, no doctor will never say that there will be 100% recovery after this. Okay, that there is always a slight percent, 4 to 5% chances of risk. Certain risk percentages are there, which the doctors will clarify while taking the informed consent. Okay, when the informed consent is taken, what risks are available, the percent of risk. Okay, the percentage of complete recovery. Okay, the guarantee of a complete recovery is not given for any surgical cases. For every surgery, there always lies a small percent of risk that may lead to death. Okay, so if because of any natural consequences, okay, natural consequences pertaining to the surgery that was carried out, which led to death, or which led to any harm to the patient, that is not a foundation to go for a medical negligence. That there always exist, to certain degree, there always exist certain risk, certain, even if it is a minute risk percentage, but still it exists. If there is an existing foreseeable risk because of which the patient lost a life, or the patient was caused some harm, that does not constitute medical negligence. Okay, when proper treatment is given and death occurs even after giving proper treatment, and still the patient passes away, or because of the process of the disease or its complication, the patient passes away, uh, the doctors or the hospital cannot be held under medical negligence. Okay, so that is a damage suffered by the patient. Next, the burden of proof lies on the complainant. Since the judicial officers who are presiding over the courts and the consumer forum, not necessarily all these officers are from a medical background. Okay, they may be from various backgrounds. Mostly they are from the LLB background. Okay, they have studied law. They do not know much about the medical scenario. They do not know much about the medical terminologies. Okay, how to read a case file. Okay, these things are not in their field of work. Okay, so naturally the burden of proof will fall upon the complainant. The patient has to bring forth the proof that, see, you can read it here, you can see here how it was done, etc. The burden of proof is on the patient's side. They have to collect the proof and bring it to the courts. And even under the courts, expert advisory committee is present, who are from the medical team. Okay, and it will be for the parties to place a necessary material and knowledge and experience which the members will have in the fields indicated in the act, would be enable them to arrive at their findings of the basis of the material. For example, whoever is expert in a field, okay, and who are from an unbiased opinion, they are brought in as an expert to finally deduct and conclude the case. Okay, but still all the material knowledge and experience has to be put forward to in front of these experts as well, not just the court officers, but also in front of the experts, and they will decide, and their decision usually will be allied with the court's decisions as well. Okay, so that is the burden of proof. It lies on the complainant. They have to get from the medical records from the MRD department of the hospital. They have to go to other hospitals to verify and conclude their experience, and then bring it back to the court. Then res ispa loquitur. So this is the Latin term. Okay, this maxim is derived from the Latin language, which literally means the things speak for itself. For example, giving wrong blood. Okay, giving A positive to a B positive patient. Okay, so it's a gross medical negligence. Okay, and you do not require much further proof. Things speak for themselves. Okay, for example, the case that you will find in your textbook on page number 75, in the fourth paragraph, it's of baby Geeta versus the Cosmopolitan Hospital. Okay, in the year 2006 this case was running. Okay, the judgment was passed. So what happened here, the story is that a postpartum baby was delivered after giving pitocin. Pitocin is an oxytocin injection which induces labor. Okay, so after giving pitocin, labor was induced, and after that, when the child was delivered, the child had high fever, the child had convulsions, epilepsy, and breathing difficulties. Okay, and even after all these symptoms that were persisting after giving pitocin injection, after 16 years of 16 hours of discharge, immediately the child suffered from birth asphyxia, and because of which the child had a permanent damage in the brain cells, which led to lifelong mental retardation. It is not reversible. Okay, and it went to an irreversible condition just within 16 hours of birth. Even when all the symptoms were there, the hospital didn't suggest the patients for further treatment. Okay, the hospital didn't advise them what to do, and the entire delivery was treated as a normal delivery. Okay, even when the child had all these symptoms, that it was not considered under a complicated delivery. It was treated as a normal delivery, and the child was not given proper care even after birth. When the child was not even drinking milk properly soon after birth. Okay, no appropriate measures and care was taken. Postnatal care was not given to the mother. Okay, so, usually postnatal care is given to all the mothers, normal delivery, C-section, complicated births. Okay, for every postnatal delivery, specific care is given. Here, even under a complicated delivery, okay, the specific care was not given. Okay, and this was more than enough. This act from the Cosmopolitan Hospital was more than enough. There was no further proof required. Okay, antenatal care was given or not, we do not know, but postnatal care was not at all given. And this kind of action will speak for themselves. There is no further proof or judgment required. It is seen that the liability, okay, the liability lies on the hospital and the practitioners there. Okay. So that is res espa loquitur. The harm caused is so grave in nature that we do not require much proof. Okay, it is visible, it is very well visible who is at fault. Then coming to the CPA Act of 1986, that is the Consumer Protection Act. So earlier we had this debate. Before 1986, the debate was, should we put the healthcare services under Consumer Protection Act? Okay, nowadays it is. Okay, healthcare services comes under Consumer Protection Act. So in a landmark, this was a landmark case, the fight between the Indian Medical Association, then it was an Indian Medical Association, now it is the National Commission for Medical Science. Okay, so the Indian Medical Association versus BP Shanta, that was the case, and the Honorable Supreme Court said that hospitals and the doctors, the services provided by the doctors and hospitals are covered under the CPA, but if the services are given free of charge to all the patients, then it will not be covered under CPA. Okay, if the patients are charged for the services given to them, treatment given to them, it definitely comes under the CPA Act. Okay, so here the contract for personal service, based on that definition, the Supreme Court came into this conclusion. But when it comes to contract for personal service, it's kind of a master slave kind of relation. Okay, when we talk about contract, it's kind of a master slave kind of relation. The slave has to completely obey the master. Okay, and the master is supposed to be someone who has all the knowledge, and in relation to the slave, the master has much of an upper hand. Whatever the master says, the slave has to follow. But when you talk about a professional relation between a doctor and a patient, it's not like a master slave relation. Okay, so the services rendered by the doctors will never come under personal service. Okay, the services given by the doctors will never be come under personal service. Okay, so that's why it's not a master slave kind of a relation when it comes to a professional medical practice. Okay, a professional such as a doctor can only advise the patient to follow it or not to follow it, is the patient's choice. Okay, So that's about the CPA Act. Is medical services under CPA Act? Definitely yes, but unless the medical services are given free of cost, all the medical services are under CPA Act, Consumer Protection Act. Next, coming to the most common medical malpractice, negligent medical advice, not examining the patient properly and based on wrong examination, giving wrong advice. So that is negligent medical advice. Pregnancy and birth injuries are again the most common ones we see in India. Prescription and medication errors. These are the quality indicators of a hospital. Okay, how many prescription and medical errors took place. Okay, that constitutes a quality indicator for the hospitals. Then we have surgical negligence. Any malpractice or negligence in taking care of the patient's safety while performing a surgery comes under surgical negligence. Medical misdiagnosis medical misdiagnosis will not come under medical negligence, because if it is an error of judgment of the doctor from the doctor's side, that will not come under medical negligence. So what constitutes a medical negligence? Okay, the answer to the question is given in your textbook. So from exam point of view, these kind of topics are important. Okay, what constitutes a medical negligence? Page number 76. So nowadays it's after the NMC was formed, it's a controversy. Okay, allowing the homeopathy doctors and the Ayurveda practitioner doctors to prescribe allopathic medications. Okay, so that comes under medical negligence. Okay, under medical negligence, if you have practiced in a specific science of medicine, in a specific section of medicine, you are only supposed to treat patients, give them advice and prescribe medication under that particular science only. Okay, an Ayurvedic practitioner is not supposed to prescribe allopathic drugs to the patient. Okay, if they do such acts, it's definitely a medical negligence and they can be tried in court. Okay. What does not constitute medical negligence? For example, any risk that is already present in the surgery. Okay, and when in the informed consent, when it is mentioned, see, even though we are carrying out the surgery, the chance of recovery is only this much. The chance of death is this much. Okay, there is always a small minute chance of death when all these things are informed in the informed consent. And if the surgery goes bad and we lose the patient on table because of natural consequences, natural risk that were already present before the surgery, okay, because of such reasons the patient passes away, you cannot try the doctor in the court. Okay, the doctors or the hospital cannot be charged under such cases. So that will not come under the medical negligence. Death that takes place because of natural consequences or deteriorating health. Okay, not able to cure cancer, not able to prevent cancer from spreading. Okay, these things will not come under medical negligence. Okay, the various examples are given in your textbook about various cases, landmark cases that has took place in India. It has been given. You can go through that, page number 76 and 77. Please go through that and understand the conceptual questions here. See, you can expect these kind of questions in exams as well. So that's all for today about medical negligence.